case to let you talk to him.
Excellent. Thank
Okay,
you.
but we do have Mr. Liuski, so let's do that and then we'll take a break. Okay, this is file 25-7007FH. Up for a docket call. And Mr. Gilbert, do you know what the status here is for Mr. Liuski?
Yes, please, the court, we do have a plea agreement for, it is, yeah.
All right, Mr. Liuski, would you please stand and raise your right hand as best you can for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help God. You can put your hand down. And Ms. Goodrich, are you going to later file an amended information?
Yes.
Mr. Liuski, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen very carefully. If you have a question, ask me. If you need to talk to Mr. Gilbert for a minute, you just say so, okay? Now, the charge of attempted absconding is a high court misdemeanor, punishable by up to 2 years and or $5,000 fine. And because it was committed while you had another felony pending, it is a discretionary consecutive to the charge that you're serving on. Do you understand the maximum penalty that you face?
I do, Your Honor.
All right, did you read and understand the rights listed on the advice of rights form?
I do.
And you signed that?
Yes.
Do you have any questions for me or for Mr. Gilbert about any of those rights?
No, sir.
Do you understand if you plead guilty, you will give up those rights and not have a trial? And is that what you're choosing to do today, sir?
Yes, sir.
If I accept your plea, you're giving up any claim that it was caused by any promises or threats that you don't put on the record today. Do you understand that?
Yes, sir.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission to appeal, which you would do by filing an application. The types of issues you could raise on an application are very limited, much more limited than if you were convicted after trial. Do you understand this? The agreement provides an exchange for the plea to the attempted absconding, the original absconding charge to be dismissed. Do you understand that plea agreement?
Yes, sir.
Has anybody promised you anything else? Has anybody threatened you? Is it your own free choice to enter that plea? Knowing all that, how do you wish to plead the charge of attempted absconding the bond?
Guilty, sir.
So back on February 12th of 2025, were you on a bond in a felony case to this court?
Sure.
I'm sorry?
Yes, sir.
Okay, and then you had a court date and you failed to appear for that court date, is that correct?
Correct.
Did that result in the forfeiture of that bond?
Yes, Your Honor.
All right, Mr. Gilbert, you satisfied with that factual basis?
I am.
Ms. Goodrich?
Yes.
And Mr. Gilbert, you're aware of any other promises, threats, or inducements?
I'm not.
Ms. Goodrich?
No, Your Honor.
Mr. Gilbert, have I complied with 6.302?
I believe the court has. Thank you.
Ms. Goodrich?
Yes.
All right, Mr. Liuski, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So I hereby accept your plea. I've got calculated that your out date is tomorrow on the sentence that I gave you before. Does that sound right?
Correct.
Okay. All right, and we did just do a pre-sentence report. Ms. Goodrich, is there any need that you would have for further pre-sentence report?
No, Your Honor.
Mr. Gilbert,
No,
would you want immediate sentencing?
I would if I could, Your Honor.
Okay, go ahead with any allocation.
Well, Your Honor, I believe if you look at the sentencing guidelines on the attempted absconding, you'll see that it is an age grid, and pretty much everything in there is less than 0 to 17. I don't believe a PRV wise, he gets all the way to the far end where there would be some jail. He understands that because he was sentenced, that the time that he has served is technically dead time, but he has served going on 4 months. I'd ask the court to take that into consideration. This is a situation where he didn't show up for sentencing. He understands that he should have some, and there should be some punishment for not coming back, but I don't think this is a scenario. This is a man that walked into this courtroom with no felonies, and because of his, and he takes responsibility because of his actions, now has a criminal record. I would ask the court to take that into consideration, possibly sentence him to time served.
Okay, Mr. Liuski, you don't have to tell me anything today, but you're allowed to. Is there anything you want to tell me, sir?
I'll never do it again. I can assure you that. I learned my lesson. I did.
All right, thank you, Ms. Goodrich. Any recommendations from the people?
Yes, Your Honor. Prior to this recent felony conviction, he had 5 misdemeanors, but 3 of those were driving while license suspended. It looks like he spent 84 days in jail since February 11th, so I'd ask for time served.
It'd be a little bit complicated for me to assess any jail and calculate credit because he wouldn't be entitled to the credit for the time that he's serving on the sentence that I previously gave him. So if that's really sort of the intent of the parties, I can get there by just giving him a fines and costs. So I think, am I remembering right that he had a delay of sentence that he didn't show up for?
Yes.
All right, so Mr. Liuski, I mean, it's, you know, it's kind of tough for us to wrap our head around the, I hesitate to use this word, but I can't think of a better one, the stupidity of not showing up for court when you had such a lenient outcome extended to you. And as a result, you have a felony conviction. Now you have a second felony conviction and you've been in jail for almost 3 months. So none of that needed to happen. It only happened through your own decisions. Doesn't make any of us happy about it, but we have to do those things to vindicate that folks have to show up for court. And when they don't show up for court, bad things flow into their life. But I think there's no further need for public safety or for rehabilitation or even for punishment to deal with this further. So I'm going to assess fines and costs only. $68 in state cost, $130 in a crime victims assessment for a total of $198. Upon your release, you have to make payment to the clerk's office. If you can't pay that in one chunk, set up a payment plan with our office. We're going to enter a judgment today on the attempted absconding. So you can file an appeal if you wish by filing an application to the Court of Appeals. If you want a lawyer, I'd appoint one for you, but you'd have to make that request within 6 months. We're going to hand you a piece of paper explaining those appeal rights and ask you to initial 1 copy for us. The other one is for you to fill out if you want to take an appeal. Do you have any questions for me, Mr. Liuski?
No, you're not.
Okay. Now, when you get out tomorrow, please stop by the clerk's office and make that payment, or my office to set up a payment plan, because it would compound the bad decisions if you end up going to jail on a warrant for not paying that fines and costs.
I'm not sure how much money
That's
I
fine.
have.
Set up a payment plan with what you can do.
Okay.
I do have the amended information making an attempt.
Okay, thank you. We do see the Chippewa jail, so let's do that with Mr. Oliver.
If I just need a moment to meet with him.
Okay, I wonder, I hate to keep them waiting, but maybe we should do Mr. Fields since he's here then first.
Whatever we do.
So let's call People v. Aaron Field.